Hi everyone, Elisa Schatzman here, President and founder of the Legal Accountability Project. I want to talk about the disciplinary order that was just issued regarding Second Circuit Judge Sarah Merriam. This was the second disciplinary order issued by Chief Judge Livingston against Judge Merriam over the past few years. As those who follow LAP's work may know, in 2023, Judge Merriam was disciplined for an abusive and overly harsh work environment. Some insufficient discipline was meted out. She would check in with the chief judge periodically and would watch training videos. And then LAP immediately began to receive outreach from incoming clerks and then clerks to Judge Merriam expressing concern that the work environment had not improved and that Judge Merriam and the judiciary officials tasked with enforcing the discipline were not complying with the disciplinary order. So LAP filed our first complaint as an organization and the second one against Judge Merriam in December of 2025. So disciplinary order was recently issued, confirming that Judge Merriam continued to mistreat her clerks, issuing some more, toothless discipline. Judge Merriam agreed to check in with the chief judge and do some management training. This is another example in light of Judge Eleanor Ross. We all know about Eleanor Ross, the judge just reprimanded for having sex in her chambers and earshot of clerks and lying about it. This is another example of a judge behaving badly and being improperly disciplined. But I also want to mention, because anybody who reads the order will see that the chief judge took this opportunity to take some shots at me and at LAP to kind of address a few things. Any organization or individual is legally empowered to file a complaint under the Judicial Conduct and Disability Act. LAP regularly receives troubling information from law clerks about abusive work environments. And frankly, when the circumstances demand it, we can and do file complaints. This was our first one. This is an example of flaws in the judicial complaint process, which relies on judicial law clerks, young new attorneys, to blow the whistle on their powerful superiors, which they rarely do, because remember, they are not legally protected against retaliation under Title VII. They are exempt. We need a better complaint process, and I will say the judiciary relies on informal discipline under the Employee Dispute Resolution Plan. That does not have any enforcement mechanisms. That does not have any punishment. The Judicial Conduct and Disability Act, a formal complaint, is the only way to get a judge disciplined.